Hello everyone, I welcome you back to our channel. This is Legal Mindset at the back, and today we are going to handle a very keen topic in law. This topic is so paramount to your understanding of the law. It is sacrosanct and very important. So, the topic you're waiting for is the lawmaking process. So, what should you know about the lawmaking process? You shall find it in a number of course units, legal methods, introducing law. You can find it in constitutional law, administrative law. It is a topic in a number of course units. That's why I said you should hang on until the end of this video, where I shall show you all the principles governing the making of laws. What is the lawmaking process? You can also call it legislation. Now, legislation is the process of making or enacting laws, whether in written, in a formal procedure, by the respective branch of government. So what is that branch of government? It is called the legislature. So what chapter provides for the legislature? That is chapter 6 of the 1995 Constitution. And if you go to Article 77, clause 1 of the 1995 Constitution, you shall see that it creates parliament. There shall be parliament of Uganda. And if you go to Article 79, clause 1 of the 1995 Constitution, gives parliament power to make laws. It provides that parliament shall have power to make laws for the peace, order, development, and good governance. So, parliament under Article 79, clause 2 of the 1995 Constitution can delegate its power to make laws to other bodies. So, but those other bodies cannot delegate their power to make laws. That is the principle of delegatus non potest delegale. A delegate cannot delegate. So, let me give you some of the reasons why the laws are made. All of what I'm discussing is what I expect you to put in your introduction when you come to a question of the lawmaking process. You shall first define it as we have done. Then you give the provision of the parliament. You give the provision which mandates it to make laws, and you give some reasons in your introduction. And the reasons for making laws, they are in Article 79, clause 1 of the 1995 Constitution, that the laws shall be made for peace, order, development, and good governance of Uganda. So there are some principles followed when making laws. Legislation, some of those principles are: legislation should be made clear, simple, and precise for the people to understand it. Legislation should also be put in a clear language. It should include an interpretation section. That's why each act you see has an interpretation section. And the legislation have a neutral language. They should be put in a neutral language. So now, allow me to start the lawmaking process of parliament. The lawmaking process of parliament is also called principal legislation. You can also call it primary legislation. Those are the acts of parliament. But if you're talking about principal legislation, lawmaking process of parliament, you should put in your head that Article 79, clause 1, gives parliament power to make laws. And Article 91, clause 1 of the 1995 Constitution provides that the power of parliament to make laws shall be exercised in bills passed by parliament and assented to by the president. So the process will rotate around bills, which bills will be passed by parliament, and the president's assent will make that bill a law, as we shall see in our video. Hang on until the end of this video. So we shall now see there are two forms of bills made by parliament. We have what we call the government bill, which is made by the all members of parliament. And we have, and that government bill is sponsored by government. We also have the private member bill. Only one member of parliament comes and says we need this law. For example, a very clear example, the anti-homosexuality bill of 2023 was brought and initiated by Honorable Asuman Basalirwa, the MP of Bujiri district. You get. Now, those are the laws made in parliament. We are on principal legislation. We shall also do a video of subsidiary legislation. But today we are handling lawmaking process of parliament. Let us now dive into it. The legislative process of parliament. These are the steps you should follow. I urge you to pay attention, be very keen, because you need to understand each step. So, step number 1, we shall start with what we call the pre-legislative consultation. Under the pre-legislative consultation, the lawmaking process begins with a consultative process for which government may introduce a consultative document. This document comes in the form of a green and white paper. So this consultation is that we are trying to make a law, but is that law already in place? You get? Because you may make a law which is already covered for. So we are going to see the green paper. What is the green paper? What is the white paper? Now, the white paper is the one on which the new law, which has not been in existence, is written. You get? But for the green paper, we write there a law which has been in existence, but we write the improvements that should be put in that law. Some improving policies to amend on the existing law are put on the green paper. If we are introducing a new law, we write it on the white paper. That is the pre-legislative consultation. Now, we shall go to the next step, making and submitting a report to the concerned minister. After step 1, we shall make a report and submit it to the concerned minister. Why? The concerned minister shall see, is this law relevant? Do we have the finance to support this law? And after, that minister shall approve, shall take that law. This is the third step, approving through cabinet. You get? That minister shall take the bill, shall take that law to cabinet for approval. So, cabinet will also look into that law. It shall look in the forms of finance. Is this law financially good to us? Can we support it? Is it relevant? Doesn't it contradict with the existing laws? Isn't that law covered for already? So, after that step, we shall look at this at some certificates accompanying that law. We can look at the certificate of compliance in case it complies with the existing laws, the certificate of financial implication if the finances are there to finance that law. We shall go on to the next step, the approval by cabinet. So, we have been talking about the financial, the compliance. If the law complies with all of those, it shall be approved by cabinet. And after being approved by cabinet, the law shall be put in the gazette. Now, this step is step 6. It's called publication in the gazette. Now, on publication in the gazette, the first parliamentary council will authorize the government printer. The government printer is called the Uganda Printing and Publication Corporation. So, the Uganda Printing and Publication Corporation, UPPC, prints and publishes the bill to the gazette. So, the ministry concerned will issue a local purchase order issued in form of issued to the government printer to cover for the costs of the printer. You get? The local purchase order will include all the monies to cover for the cost of the for the money of the printing. Now, after that publication in the Gazette, the ministry concerned will now have to supply that the copies of that bill. Now it is a bill to the clerk of parliament, to use to the use of the parliament, the parliamentarians. So those parliamentarians, the members of parliament and other stakeholders in parliament shall be given a copy each to have the law, because they are now going to start discussing on the law. Now, step 7 is introduction of the bill to parliament. We have seen that step. Now we are in parliament. We are making the law in parliament. You are going to hear of the first reading, the second reading, and the third reading, and the assent by the president. So, here, when the bill is introduced to the to parliament, as we said, each member shall be given a copy. So, the bill goes through the process of the parliament necessary for passing it. So, we shall use the rules of procedure of parliament. We shall start from rule 18 up to rule 21. Yeah. So, the first reading, in the first reading, the first reading is provided for under rule 128 of the rules of procedure of parliament. So, in this, the first reading is like a formality. It marks a formal introduction of the bill in parliament. So, if it is brought, it is read by the clerk of parliament, who reads the short titles of the bill. And the bill is then committed to the relevant committee of parliament for consideration under Rule 29 of the Rules of Procedure of Parliament. That relevant committee checks the law. Is it valid? Is it good for Ugandans? Is it complying with the law? Isn't it already provided for? So the committee invites the relevant ministers to introduce the bill and other stakeholders with their views to the provision. All of those members of the committee shall give a view to the bill. What is their position? What do they say about that bill? And after revising the bill, that committee will bring back that bill in parliament after 45 days. And they shall submit their findings in the bill to the floor of parliament. And after submitting their findings to the floor of parliament, we shall now go to the second reading. And in the second reading is where the members of parliament exercise their duty of making laws. They debate on the law. And the second reading is provided for under Rule 130 of the Rules of Procedure of Parliament. Here, the clerk shall read the bill aloud and shall read the short titles of the bill, and that shall be regarded as the second reading. In the second reading, the main principle of the bill are debated for the first time. As I told you, the members of parliament and other stakeholders in parliament will tell us what is their view on this bill. They will debate and they will determine whether the bill should be recognized or should not be recognized. But after recognizing it, after giving their proposals, the committee of the all-house stage, this committee of all-house stage deals with the provisions of the bill clause by clause, and all proposed amendments of the bill by the committee we talked about in the first reading. You should indicate the committee of the all-house stage in the second reading, which investigates the bill clause by clause to see whether it is in compliance. Now we shall go to the third reading. And at the stage of the third reading, the bill is not debated. The debate is now done, and it is passed as a formality. You get? A motion of the bill shall be now read for the third time in parliament and shall do a pass, shall be passed as Rule 137 of the Rules of Procedure of Parliament provides. Now, after that, the bill is now ready for assent by the President. So, here, the law cannot become a law. That bill cannot become a law before the President assents to it. But there is an exception. If the President refuses to assent to it, if it is taken to the President 3 times, the Parliament shall sit with 3 thirds and pass it as a law. Now let us see how the President's assent is done. If you go to Article 91, Clause 2 of the 1995 Constitution, a bill is passed by Parliament and shall, as soon as possible, be presented to the President for assent. So, Article 91, let us continue. Article 91, Clause 3A of the 1995 Constitution states that the President shall within 30 days assent to the bill. They shall give him a period of 30 days to look into the bill and assent to it. Assent means to accept the bill. You can look at that homosexuality law which the President refused to assent to. That is a very clear example. So here, that article states that he shall have only 30 days. If you go to Article 91, Clause 3B of the 1995 Constitution, it provides that the bill shall be now returned to the Parliament. If the President refuses to assent to it, it shall be returned to Parliament with a request that a particular provision or the bill itself be revised and the recommendations of the President be put in. You get? And let us now continue to Article 91, Clause 3C of the 1995 Constitution, which says that the President shall notify the Speaker in writing that he or she has refused to assent to the bill. He shall give him his position that have refused to assent to the bill because of this and this, so that they can implement it. And after, that bill shall be taken back to Parliament. Parliament shall revise and put the things what the President wants to be included or what the President wants to be excluded, and the bill shall now be taken back to the President. And that is provided for under Article 91, Clause 4 of the 1995 Constitution. Now, we shall look at Article 95, Article 91, Article 91, Clause 5 of the 1995 Constitution. This one is very clear and it states that where the President returns the same bill twice and the bill is passed for the 3rd time with the support of at least 2/3 of the members of Parliament, the bill shall become a law without assent of the President. It means a bill can become a law in two ways. Either the President assents to it, or when he refuses to assent to it twice, it shall become a law when at least 2/3 of the members of Parliament accept it. Okay, now we are going to look at our last step. We have seen that now the bill is becoming a law after assent by the President. And Article 91, Clause 8 of the 1995 Constitution provides that a bill passed by the President, by Parliament, and assented to by the President, all which has become a law with support of at least 2/3 of the members of Parliament after refusal of the President to assent to it, shall be an act of Parliament and shall be published in the Gazette and shall become a law. Now we see our law is now ready. You get? So that is the lawmaking process. To summarize it all, the lawmaking process is very simple, and it shows us that the power to make laws is in Parliament, but it should be approved by the President. And we started with the pre-legislative process, where we saw the consultation, we saw We saw the bill going to the minister. We saw the bill being checked if it can be financially supported. With that, we now came to the parliament. We saw the first reading, the second reading, the third reading. The first reading was a formality. The second reading, the members of parliament debate on the bill. The third reading is also a formality. Now we came to the assent of the president. And we saw in assent of the president assents to the bill twice. If he refuses, two-thirds of the parliament shall accept and the bill shall become a law. Thank you very much for watching Legal Mindset at the Bar. And I urge you to subscribe, because by subscribing is the only way you can push us. And I urge you to share with your colleagues if you find this work helpful. Thank you very much.